Will Congress leader Rahul Gandhi be reinstated by the Lok Sabha Secretariat in time for the debate around Manipur? That's the big question on our special broadcast today. I'm Barkha Dutt, here with the Mojo story. In focus is the big victory for the Congress party in the Supreme Court. The Supreme Court put a stay on the disqualification of Mr. Gandhi while calling his remarks somewhat distasteful in the context of what has come to be known as the Modi surname case. The Supreme Court questioned the judgment of the trial court, asking why the trial court had believed that a maximum punishment, which is that of 2 years, which is what led to the disqualification of Mr. Gandhi from Parliament, was necessary. Now, of course, this is not an overturning of the conviction itself, but it does mean that Rahul Gandhi is now Lok Sabha member of Parliament again. But will the Lok Sabha Secretariat, will the Lok Sabha Speaker reinstate him immediately? Remember, Tuesday is when the no confidence motion and the debate around it brought by the opposition alliance India begins. In focus is Manipur, where we've been on the ground all of this past week. To talk about this as well as all the other key political legal cases, I should call them in the news. Let's welcome our newsmaker on the broadcast today, Dr. Abhishek Singhvi, very much the lawyer of the moment, is with us. Thank you, Dr. Singhvi. Always a pleasure. Let's start with the Rahul Gandhi case. What is your takeaway from the Supreme Court intervention? The Supreme Court did not endorse the remarks or the language used by Mr. Gandhi. In fact, the court found the remarks to be distasteful, but at the same time, it did not agree with the 2 year conviction. What is the big takeaway, according to you, from the Supreme Court judgment?
Firstly, Barkha, the only issue before the Supreme Court was whether a conviction should be stayed or not, leading to a stoppage of disqualification. That was the sole issue. On that issue, the Supreme Court has 100% given a 360 degrees verdict. Yes, disqualification must be stayed, conviction must be stayed. No ifs, buts, or conditionalities. Number three, it is vital because it restores parliamentary membership to a person who is the former president of a 135-year-old party in the world's largest democracy. It is after three earlier opposite verdicts. And the learned judges, who amazingly, by the way, had read matters which ran into thousands of pages and were in fact quoting evidence from the record at page so and so, to the astonishment of both sides. They put in a lot of hard work in reading that. Were very rightly critical of the High Court order, which had not, adverted to the relevant facts. So all in all, it was clear. As far as your point about the remarks are concerned, this is not an appeal against conviction. This is not an acquittal versus conviction appeal. That
Yeah.
will be decided in the fullness and ripeness of time. They actually said in the context that had the Rafael Supreme Court judgment come earlier, it might have acted as a better guidepost. Now, obviously, that was speculative because the Rafael judgment came on 14th of November 2018. And this particular Kolar speech, the one you're talking about, the defamation speech, happened in April of 2018, 6 months earlier, 8 months earlier. So this is, purely, obviously, a speculative, hypothetical remark.
But can I ask you? The BJP suggests that the court's observation or that this was not the best language is a kind of rap on the knuckles of Mr. Gandhi. Do you see it that way?
I've been saying this for the last few days. It all depends when you enter a zoo or a place and you see an elephant or a horse and you start describing the last hair on the tail of that horse, ignoring the elephant, ignoring everything in front of you, because that's your nazariya. You will see that 1 millionth speck, but you won't see the actual picture. Now, I can't help it if your nazariya is distorted, and that's what's happening.
What did you make of the sort of open-ended remark about judgments coming out of Gujarat?
See, first of all, in the dialectics of discussion, I think people underestimate the importance of these things. It is a give and take to elicit the best from each side. One. Two, in your question is very much more important than you might think. Because when this happened, a couple of minutes later, the Solicitor General of India, can you hear me, Barkha? I can't see
Yes,
you.
yes, yes, yes. You'll be able to see us in a moment. We were just running Rahul Gandhi's tweet. Go
The
ahead. Yeah.
the Solicitor General of India appear on the screen. And I say it, of course, we joke around on the court all the time. So I say in jest, miraculously appeared. He's only, in a sense, a pro forma party because it's between two individuals, the complainant and the alleged defamer, Mr. Rahul Gandhi. The state has no role. And he then, very right, very, very moderate language, said that your lordships may desist from this and it might have a demoralizing effect, etc., which is entitled to. I mean, he's a law officer and he comes.
Mm.
After that, what happened is important. The court stuck to its stand and said that they also are very restrained and hesitant before they make such remarks. But where necessary, in the course of adjudication, of course they make the remarks. They make it everywhere. We can't have a very tender foot approach in a particular case. In the adjudicatory matrix, this was completely relevant. And then the learned judges said that they've had experience of 2 or 3 orders like this specifically. Now, I want to just step back for a half a minute more and tell you what was the heart of this obviously perverse conclusions in the order. One, I'll give 2 out of 10, 12 examples I gave the court. You know my arguments lasted about 20 minutes. So I'm only taking a minute and a half for giving you 2 examples, which are egregious, which led to these comments. In a long judgment of 125 pages, number 1, a offense is invented, 171G, which is not argued by the complainant, not arising in the case. The section doesn't apply. The court invents an offense, which means that a person in the course of candidate versus candidate does something wrong. Second is more egregious. They compare Rahul Gandhi's acts or inactions or alleged actions to heinous moral turpitude offenses like rape, murder, kidnapping, etc. They forget that this, and this is not adverted to, not dealt with, this is obvious. If I say that you've done something moral turpitude, then you must also add that look, Barkha is involved in something which is bailable, which means the police officer can give you bail, don't have to go to a court. Non-cognizable, which means I can't arrest you without a warrant from the magistrate. Compoundable, which means you can settle the case between the parties not having the state to be informed or involved. There is no in rem or statewide effect. And also 2 years simple imprisonment. I pointed out, Barkha, it's interesting for your viewers to know that in this long IPC of hundreds and thousands of sections, there are only 22 which provide simple imprisonment, and that too up to 2 years max. And this is one of those. So, how can this be a heinous offense? How can it be a serious offense? How can it be a moral turpitude offense? But para 43 and 44 of the judgment so says.
Yeah. So let me ask you this. As you know, there was another case of a Lakshadweep member of parliament who was disqualified in a similar manner, and he got relief from the Kerala High Court. But the Lok Sabha Secretariat took 2 months to reinstate him. Now we have a no confidence motion and a Manipur debate kicking off on Tuesday, which means Mr. Gandhi either gets reinstated by Tuesday morning or he skips or sits out this debate. What is your expectation?
Let me answer you point form. Number one, what you don't know perhaps is that I am doing the Lakshadweep cave also.
I don't know that. I do know that. And I should have mentioned that. Yes. Yes.
Two, I was extremely disappointed to have to move after the 60 days you rightly mentioned, a petition again telling the court that, look, how can I be kept at the doors of parliament without entering it?
Yes.
And number three, on the day I moved the petition, the date was listed in court 3. On that day, before I could open my mouth, the respondents, the government came and said, but why is this being done? We are going to allow him today, tomorrow. So virtue out of necessity was made. Number 4, I don't, in any democracy with magnanimity and grace, I will expect, and the heart of democracy is not that every word is written, what you will wear, how you will speak, how you will deal with me. It is all done by grace, magnanimity, and convention, that this should be done for the asking. At the highest, what you can ask for, and that's the last, not the first, is that a certified copy of the court order be given to me. After I give you, Barkha Dutt, a certified copy, I want to ask you, what complex question of law do you have to decide in your mind or refer to the law ministry to decide that Abhishek Singhvi should be led into parliament?
Yeah.
This man is not a fresh entrant into parliament. This man is a parliament member who's been out. He's only re-entering. And lastly, it is but obvious, it's not a political statement. I've said so in the press conference which I took. If you took 24 hours to evict me, take 48 hours to get me re-entered. There
Yeah.
has to be some grace and magnanimity. But my expectation, I will not say a lot of my expectations have been belied in a lot of things. So no point. My expectation in a normal principled sense would be maximum on Monday he should be allowed in.
You
My
went, you
fear,
went,
my fear,
yeah.
different from the expectation, and I hope that fear doesn't come true.
You went back to court in the Lakshadweep case. Suppose tomorrow you find that Mr. Gandhi has not been reinstated in the manner that you hope. Will you be knocking on the doors of? How important is it
What
to
do I
Mr.
do?
Gandhi? No, how important is it to him to be part of that debate day after tomorrow?
No, no. You see, the people who do these things don't realize that everything is not intended for courts. A lot of things are done, as I said, by grace, magnanimity, and precedent. Second, they also know that ultimately he will be in, definitely 110%. But they also know the court process takes time. Now, I can't guarantee that Mr. Gandhi will enter on Tuesday if you start playing these games, because the time between Monday afternoon and Tuesday is nothing. How do I
Yeah.
do it?
I have a last question on the Rahul Gandhi case. This particular petition is not the only defamation case against him. There are a bunch of bunch of state courts where this same case is being tried, including one, for example, in Bihar. Do you believe that after the Supreme Court's nod, as it were, to the trial judge that the maximum sentence, which is 2 years, did not apply in this case, all of those cases will fall by the wayside? And let's also remember that this case on conviction goes back to the same sessions court. So, your battle is far from over, right?
No, let's disentangle some threads here. Number one, the case yesterday is final, but final only on stay of conviction. It is not final on the merits. It was never supposed to be. The merits are not here before us.
Yeah.
The conviction or acquittal, whether Rahul Gandhi is guilty or not, has to go through the appellate court when it's pending rightly. The law is that if you stand convicted without a stay of conviction while you are deciding the appeal, then you are out of parliament. So all that was being decided by the Supreme Court, which is the entire remit alone of the Supreme Court, was this, and rightly so. It is nothing to do with the larger issue of whether he's guilty or not. Number two, guilt or not, of course, will be decided in the appeal court where it's pending. But I want to just add something, not entirely in a serious manner, but something very amazing, which I point out to the court. I told them to turn to page so and so. A chart is given. This whole thing is based in a lot of cases on the 13 crore community, which has been allegedly defamed. I pointed out in the chart 13 cases, 1-3, is the totality from Ranchi to Jharkhand, Ranchi to Patna, from Gujarat to elsewhere. 90% of them are defamation, one or two of them are like National Herald. So I told the court that, Balos, it's very interesting, and this will amuse you and your viewers. It's very interesting that in all these cases, which are the defamation cases, where you are supposed to have done this or that for the 13 crore Samuday, or in one case, in the Veer Sarvarkar case, is it not amusing and strange that every complainant is none of those 13 crore people? It's always a BJP Karyakarta. It's always a BJP high office holder. All these multitude of crores of people are defamed only by complainants who are BJP Karyakartas. So the point is that these are nothing but orchestrated political movements. I will not say that because I have succeeded in one which is not on the merits are still pending, all of them wither away. But they are all orchestrated political movements. They will have to abide by their own process. But we are hopeful of a win on the merits in the appellate court. We have a good case on merits. And let us see
Okay.
what happens there.
Okay, let's move on to another big political story, a case in which you've been involved, which is who wields what powers in the national capital, right? The Supreme Court, in a case that you fought, gave administrative powers to the Kejriwal government. In this case, the Kejriwal government, but the elected government of Delhi, whose ever government it may be. The ordinance is the BJP's answer. They have the numbers. Do you still have legal options?
Of course, we have legal options. We are very confident of winning a victory in the unlikely event that the bill is passed. I'm
Why
choosing
do you
my
call
words
it
carefully.
unlikely? Why do you
No,
call
I'm
it
just
unlikely?
well if the bill is passed. It was an unlikely event till 2-3 days ago. You're right. It looks more likely now. But I'm not concerned about the arithmetic. I'm the lead speaker. I'm the opening speaker on Monday. on this bill, and given certain parties stand, which as they
Your,
say,
your old colleague among them, Jagan Reddy among them.
yes, more than that. I mean, many of them, and I'm reminded of that saying, Barkha, that when they came for the Jews, you kept quiet, and then they went for the communists, and then you kept quiet. So, sometime for some of the parties who are today supporting, they have to ask themselves that there has to be somebody standing by them, because this is going to happen to all. This is a fundamental assault on federalism. Anyway, when the matter comes, I think on the Supreme Court level, which it will come shortly after, if it is passed. Obviously, if it's not passed, then nothing in the Supreme Court left. Matter is over. I'm assuming it is passed. Uh, I think this is one of the weakest constitutional bills. I think I have no doubt in my mind that we will succeed in the bill. Of course, I'm never presumptuous about court proceedings. Let me give you in 2 seconds, in 15 seconds, the principal heads of arguments. One, it turns civil service accountability to the political executive on its head. Two, it turns political executive accountability to the voters who elect that political executive on its head. Three, it decimates federalism. Four, it converts Delhi government to a cipher without a constitutional amendment. Without a constitutional amendment. You can do it with a constitutional amendment. Number five, it actually negates the very purpose created 30 years ago. And I want to ask a question, which I'll ask in Parliament also. Why is it that no political party, Barkha, of any political color, BJP, Congress, Third Front, wherever the political color is the same in center and state, NCT, or different in center and NCT, nobody has tried this for 30 years. No one. Why? Because you are trying to be a control freak sarkar. You
A
are not
control
able
freak
to
Sarkar.
you are
That
not able to digest a defeat in the elections. Now today I'm not about Kejriwal, I'm not about NCT. It could be you tomorrow, it could be me tomorrow, it could be any federal structure which is the idea of giving power to the voters of Delhi. And therefore, the legal point is it violates the basic structure. All these principles come out of the basic structure.
two questions, and some you've answered before. The Chief Justice, in his own judgment, which gave you and your
Right.
client in this case relief, you said that he wasn't saying, "Hey, go ahead, Parliament, make a new law." He was saying, "If you want to, go ahead and bring a constitutional amendment. That's your right." You're saying this is not a constitutional amendment, granted. But let's imagine a scenario: this bill goes through. One, what do you then go to the court because it's already been turned into law? That's the first question. Two, the court itself did not stick to its guns. It passed it on to a larger bench. It could have said, no, we won't entertain this review petition.
No, let me explain to you one by one. Number one, the court has rightly put it before a constitutional bench. We only wanted expedition, so we said you may consider that you can do it without a constitutional bench. But they had equally good ground. We agreed afterwards. Afterwards, we agreed let it be constitutional bench. We are expecting the constitutional bench to be there by the end of the month, hopefully, after the 370 hearings, etc. over. Number two, in a sense, the constitutional bench will give very much greater weight to whatever judgment comes. If the Delhi status is to be clarified, it should perhaps be, in all fairness, by a constitutional bench. Number three, the real question you're asking, which you've not so directly asked, which I'll formulate for you and then answer, is that there is a passage in the judgment which I succeeded in, saying that Delhi being a special status, Parliament can pass laws for it.
Yes.
Absolutely correct.
Yes.
But they don't tell you the next sentence. Parliament can pass laws for NCT, even regarding List 2, but those laws under Article 239 AA7 have to be for reinforcing, supplementing, assisting ancillary provisions to reinforce the governance of Delhi. Now, just see the way they have interpreted literally. Parliament can pass a law. Now, the entry list 2 has, let's say, 50 entries. Give me 1 minute, half a minute. List 2 has 50 entries. Assume 3 are out, 3 we are not talking about in Delhi. Those balance 47, suppose Parliament passes 2 judgments which say in all the 47, the legislator is Home Ministry, not Delhi. That is, technically it is permitted because Parliament can pass laws. But can Parliament pass a law which makes that entire constitutional amendment 239 into one large zero? You cannot use the scalpel to kill The scalpel is intended to heal and cure. So the idea of 239(7)(a) was to allow parliamentary intervention to reinforce the Delhi structure, not to decimate it. That's the point being missed out. And if you do that, you are violating the basic structure. Yes, you can change 239(8)(a) itself. Tomorrow
But
you
if
can
you
say,
but if you say you assented to the fact that a constitutional bench is needed to settle this issue, then the Chief Justice had that option when he first delivered the verdict, right? He upheld administrative powers for an elected Delhi government. He subsequently referred it to a constitutional bench. Now, if
no, no,
this
no, 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 no. Let me explain.
what okay,
We won a full thumping victory in the first matter, which was a challenge to a non-parliamentary law, an executive order, which said by an executive order that civil services control will lie largely with the central government. We challenged it, we won. In the
yes,
course of that judgment, one para is written by the Honorable Chief Justice's judgment saying that there is a separate provision which allows parliamentary law for Delhi. He did not give an invitation to pass such law. Subsequent to that, this law is passed. So we have to challenge it again because this law was not there. That was an executive order. Now, this law is passed in the guise of 239(7) of the Constitution and that one para in the judgment. Not understanding that the 239(9)(7), I don't want to sound technical, your viewers can pick it up and see it in the
yeah,
Constitution, is
okay.
to reinforce the constitutional structure of Delhi, which is a federal, I mean, a decentralized governance, not to abrogate it.
So let's understand this in layperson's language. Notwithstanding a scenario where this ordinance can go through and get parliamentary approval of both houses, let's imagine for a moment, hypothetically, that happens. You are saying the constitutional bench will still have the mandate to question that legislation.
Oh, yes, every legislation, hundreds of legislations are struck down as being against the Constitution. The hierarchy of laws is an executive order, a
Yeah.
delegated legislation regulation, a statute, and at the top lies the Constitution. So, a statute passed by Parliament can be challenged as being anti constitutional on grounds ABC. If the court finds that those grounds ABC of Constitution are violated, then it is struck down.
I,
The
I,
law
I
is struck down
understand.
all the time.
I understand, but a constitutional bench usually takes a long time to reach a conclusion.
No, no, no. This will take even shorter than normal. It will take shorter than
Because
normal
because
because they've already dealt with 9/10 of the subject in the judgment of 2023, 2 months ago. The
so
only
you
thing they've
haven't
not dealt with is a parliamentary law, which is obviously a new development on 19th of May for the first time.
yes,
So they have to
yes.
only add that part about 239(7).
So you haven't given up hope on being able to retrieve this victory back to your side. You're going to lose in parliament.
I've just
You're going to lose in parliament, most
I have
likely.
just said that we have an excellent case. According to me, the court, on the basis of existing precedents and their own judgment, would strike it down. But obviously, nobody should be presumptuous about court verdicts. That has to happen.
Okay, finally, on a point of law, and then I have one last political question. But on a point of law, we have the 370 hearings finally taking place before the Supreme Court. Transparently, the whole country can watch them. They've been fascinating conversations. What is the central point? And I think a lot of people who are interested in law, but also in the future of Kashmir, would be interested. What is the central
Okay.
point before the court? The Chief Justice said, we're not going to concern ourselves with outcome. So don't come to us and tell us this is better in Kashmir today, that is better in Kashmir today. That's not in the remit of this trial. What, according to you, is the central point in this hearing?
Uh, Very quickly, because it's obviously a complicated subject, and briefly, you know, first of all, what I'm going to say now is entirely in my personal capacity and professional capacity, nothing to do with the party, because I wear many hats, and it'll be said that the Congress party stand on 370s, this and all. That's nothing of the sort. Number one. Number two, I was engaged in the first time when the petition was filed. I personally didn't have my heart in it because I think that 370 is now a done deal. It's a fait accompli.
Yeah.
The more important question is really the dilution of the statehood to a UT and the abrogation or the trifurcation, etc., which is also, by the way, in a connected batch of petitions pending before the court. Number three, if you ask me as a professional, the issue on both sides is one, can a temporary provision, which is called a temporary provision, be abrogated by this legislation or by this procedure. Now, the heart of the argument, which is at the moment going on, and nobody's prejudging it, and it's for you and the US to judge it, is that the argument of the petitioners is that the moment the Constitution Assembly or the Constituent Assembly of Jammu and Kashmir, which as you know had one till the 50s, ceases to exist,
Hmm.
370 can be removed only by, I repeat the word, only by that Constituent Assembly. And if that Constituent Assembly has ceased to exist, then 370 itself becomes unamendable, unchangeable, permanent, indeed eternal. Now that's the contention. The argument of the other side is that the framers, the debates, the section itself, the article itself created it as a temporary thing. It cannot be that the vanishing of the Constituent Assembly of J&K will mean that 370 eternally will never be touchable. Now, that's the issue, the dilemma which the court has to grapple with. But as I said, my professional view is, I mean, uh, again, please don't misunderstand me, I'm speaking purely abstract, without political part, without any
Yeah.
political party.
Yeah.
The chances of any court in India holding that a provision like this is eternal and it cannot be changed now that 2 years have passed is obviously slim.
But
The
I have a
argument which I believe which has resonance is how much or can you reduce a state to a union territory in this manner?
I have a legal question though. In the context of a uniform civil code debate, in which you have said on our previous shows, show us a draft, you have the BJP's own allies in the Northeast, Nagaland, for example, come and say that this cannot apply to us. You have Sushil Modi, the head of the parliamentary panel, looking at this question saying, I agree. These are states that have a special status. Now, I have a legal question. If the abrogation of 370 is a done deal, can you in the same breath say, but no, there are other parts of the country that have a special status which they do? Is that not a question that the bench will have to wrestle with? That if you say we want uniformity, we want one nation, one law, let's in whatever context, but you also say the abrogation of 370 is a done deal. Kashmir can't have a special status. Okay.
Barkha, it's a
Why can the
Barkha,
other states have a special status?
yeah, Barkha, it's an interesting analogy you're drawing, but if you ask me professionally, conceptually, you are wrong.
Okay.
Why I'll tell you you're wrong. You can't draw
Why?
the analogies because the question to be asked is legally, constitutionally, do you have the power to remove 370? The answer will depend on whether once the Constituent Assembly vanishes, you cannot do it ever. That question is not arising in the northeastern states at all. The
Right.
question which would be analogous is if you first abrogated 371 ABCD, Nagaland, Meghalaya, etc. And the question was then raised that look, you cannot abrogate 371. That's not the question. The question is while 371 for Meghalaya and Nagaland stands, can you have a common civil code? The answer must be no. How can I impose a civil code on you while 371 stands?
Yeah.
So
But
the
how can
two
you
are
say 370 should not stand, but 371 can? That's the question I'm asking.
because that depends on the power. Tomorrow, if there is a political consensus, there is by a majority party a political consensus. I'm not saying they're right at all. I'm not saying that they can do it by majority. Their political consensus is that we'll use our parliamentary power to abrogate 370. They
Yeah.
don't have the same political consensus to abrogate 371. If the
Correct.
question was raised that we want to abrogate 371, I don't see any power which can stop them. Tomorrow, if this majority government, the ruling government decide, I'm not saying they are right. I'm not saying I'm agreeing. I'm saying they said we have the brute power and we want to abrogate it. Which is the power which should stop them? If they get two
Yeah.
thirds in parliament, they'll do it.
So basically, you're saying it's the political consensus that has led to the striking
Yes.
down of this article that was meant to be temporary in the first place. And all that the Supreme Court, you think, would likely focus on is whether, as the powers are allocated to the assembly, whether that procedure was followed.
Yes.
Hypothetically, if we say, okay, that procedure wasn't followed, then what?
I personally and professionally, again, without any political party, without any other view, believe that court is highly unlikely to interfere.
Yeah.
I mean, that's the best I can say. I've not been presumptuous. I can't predict, but on probabilities, I'm saying this. Whereas the much greater resonance would be that you have suddenly reduced a large state into union territories. That would be an argument of greater strength and greater resonance. Again, whether that will succeed or not, I'm not saying, but that will certainly be a better
Let's let's
point.
let's let's end with a brief political question. You're a busy man. You have, as you said, even the Delhi Ordinance debate to prepare for. The India alliance. A lot of focus on why it's called India. Does that work? The Prime Minister has certainly been going for the jugular on this. The larger questions remain unresolved. Who's the face of this? Is this just an aggregate, a motley crew of folks standing together with nothing to unite them but an anti-Modi sentiment? How do you see this playing out?
I believe that the greatest and the best initiative in the entire non-ruling party opposition space has been the India Alliance. I think that if a person as high and as exalted as the Honorable Prime Minister is taking note of this acronym, I'm at the moment talking only of the acronym,
Yes.
it itself shows that there is a degree of fear, a degree of bocklahat, a degree of being surprised and taken aback, and there are attempts being made to even attack the acronym or to remove it. I think that the real devil and God both lie in the details. An excellent initiative, an excellent first step. Without the devil and the details being worked out, without God being found in the details, we are not going to get anywhere. It's not an easy task, but it must be done, should be done, and that is by putting your nose to the ground. It can be done only by a small group, maybe 5, maybe 10 people. They have to ultimately have one guiding pole star, only one, namely one person per constituency. If you can't do it for 545, do it for 500. You can't do it for 500, do it for 450. I think it requires 3 conditions precedent. Not easy, but not too difficult either. Submergence of ego, the engagement of experts and assessors to tell you on data that in
Yeah.
this constituency, Barkha Dutt is the best. Forget her color, forget her party. In this constituency, Abhishek Singhvi is the best. Forget his color, forget his party. And then, thirdly, to arrive at that consensus, because it's natural that in that place there'll be all the other people around Barkha Dutt who will be opposing her, and all the other people around Abhishek Singhvi. That has to be worked out. But if you go in this way methodically, this is the ideal time: 4 months, 5 months, 6 months. Prevents vote division. If you consolidate 90% of the 60% which Mr. Modi does not get, then, as I always say, it's both a fight and a fright for him.
Well, we live in interesting times, and it's going to be a very interesting week in Parliament and a busy week for you in court, as always. Thank you, Dr. Singhvi. Always a lovely conversation. Thank you so much.
Thank you so much. Thank you.
Take care. Bye-bye. It's great to see you here. Thank you for watching our work. If you haven't subscribed yet, don't forget to click the bell icon and subscribe to Mojo Story and support independent, robust journalism.